Welcome to Real Talk, Family Law with Richard LeBovitz.
Hey everybody, welcome into an all-new episode of Real Talk, Family Law with Richard LeBovitz. I'm your host, Mike Leon. Richard here is a seasoned Maryland family law attorney with decades of experience guiding clients through divorce, custody, and post-divorce disputes. He's known for his clear, honest answers and commitment to helping families move forward with confidence. And in today's episode, we're discussing post-divorce modifications. Custody, child support, and even alimony orders can sometimes be changed, but not always. Richard's going to explain it all in just a second. Richard, it's good to see you as always. Let me ask you here on the onset, what do you usually see people ask to modify after a divorce is finalized?
Sure. Well, once again, thank you, Mike, for having me on your show today. It's a pleasure. With regards to modification, essentially people are looking to either modify, it's usually for custody issues or access issues and or child support are really the two main issues that come up. Or minor ones where, say, as part of a marital agreement, something didn't happen yet, and we need to go to court and possible contempt to basically enforce the agreement is what happens. But it's usually the parties have reached an agreement, whether it's on a parenting plan or on child support. Someone lost their job, or they have some issues with receiving the child support, so we need to go back to court to basically fix some access issues or to modify the child support.
What other circumstances allow for custody or even like parental time modifications in the state of Maryland?
So essentially, you can always modify a custody or child support order. And alimony is a little bit more restrictive. I'll get into that in a minute. But essentially, it's really a two-part test. They have to show a material change in circumstances has happened, and it's for the good and welfare of the minor child for actually going forward. Just changing something just because I want to change is not a reason. It has to be that either you had a relocation for a job, or you're looking to possibly move out of state. It has to be something more than I just don't like the schedule. It has to be, or maybe your work schedule changed, or there was something that essentially affects your ability to follow through with the order. So therefore, you need to seek modification.
So you mentioned alimony. Can alimony be adjusted later on too? Can you break that down for us?
Sure. It really depends on what the marital agreement says about alimony, because more often than not, alimony really is not modifiable. It's really only modifiable based on very specific issues like a major disability of the party that severely limiting their ability to pay, like you became disabled or you were ill, or obviously upon death, because some of these agreements really survive practically beyond death, whereby you would have, say, insurance as it would be covering to make sure that the alimony is actually paid. But it's very limited. It can't just be that, hey, I feel I can no longer afford it, therefore I want to modify it. It has to be, something. It's very contractual. So if the agreement says it's not modifiable, you're stuck.
And you were saying a moment ago about a material change in circumstance. Can you kind of explain what that means and whether or not the Maryland courts require that for the modification process?
Sure. So modification of so for modifications, you need to show it's this legal term called a material change in circumstances. Essentially, as I said earlier, it's part of a two-part test. It's the material change, and it's for the good and welfare of the child. So going along with the standard of the best interest of the child, and most modifications dealing with a child, whether it's improper amount of support, someone had an increase or decrease in their wages, or something material happened with regards to the child. Again, if you just had a regular parenting plan and you wanted to change the 4 o'clock pickup to 5 o'clock, that's not really a material change. But if you're working, say, the day shift and you got switched to the overnight shift, and or you'd lose your job because if you didn't have a change, and that material changes your ability to spend time with your child, then that's a material change. Again, it's just more of in the eye of the beholder, saying, hey, I don't like the school district my child's going to, and I'm going to move. Just to change school districts may or may not be a material change. And if the parties can't agree, then you're asking the court to make a change.
So let me ask you on that. In those situations, are there situations like that where parents think they can change the agreement, but maybe the court won't approve it?
So essentially, the courts really have no reason not to sign off on anything that the parties can agree on. If the parties can agree on something, we can always draft a consent order for the parties to sign and file with the court. Some courts may just sign off on whatever the parties have signed off on, as opposed to sometimes they might just want to see the parties in the courtroom or on a Zoom call just to make sure that they hear them say that we believe this is in our child's best interest. But judges are not looking to essentially modify or change things, saying, no, that's not good, or that's not in the best welfare for the child, if the parties can agree on it. It's only when you have a change and the parties cannot agree, and now you're asking for the stranger wearing the black robe to sign off on it.
Richard, what kind of mistakes do people make when they try to modify an order on their own without legal support?
So mistakes is really just not being specific about what the change is, or what the basic reasoning for the change is. Like I said, I've had cases in the past where, say, you just don't like the school district, and you're trying to argue that one school district is maybe rated a 5 out of 5, and the other one's rated a 4 out of 5 on different rating websites. And it's an issue like that where you're worrying about one school or versus the other that gets to be too political, and the courts don't necessarily make those changes. It has to be more of a relocation, or your job forced you to move to the other school district, and that's why you're having an issue. So it's more of there's a subtleness to it, but when parties or lay people are unrepresented, they can sometimes make that mistake where they have to be very specific about what is the material change in circumstances and how does it really affect the child. It can't just be, me. I want the change because it's better for me. It has to be thinking of the child first, not them. If that makes sense.
Yeah, it does. And so, Richard, for someone who's listening to this episode right now, maybe they feel their current arrangement isn't working anymore. What should they do before filing anything with the court?
Ideally, they should do a consultation with an attorney, or like myself, to essentially try and figure out what it is they're really looking for, or what's the root cause of that they're trying to resolve. So if we get to the root of the problem, it might be something innocuous that maybe the other party just needs a simple agreement, or maybe we need a little bit better communication to resolve the issue. And by having the consult, we can root out what the issues are and possibly come up with a workaround or a solution.
Yeah. Richard, thank you for the time and insights on this. We truly appreciate it.
Well, thank you. Again, Mike, for the opportunity to speak with you today. It's been a pleasure.
And thank you to everybody out there for listening to this episode of Real Talk Family Law with Richard LeBovitz. If your custody, support, or alimony order no longer fits your life, you heard what Richard said, and he can help you understand whether a modification is possible and guide you through the process. All you got to do is visit LeBovitzFamilyLaw.com today to learn more and schedule the consultation. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.